Welcome to meeting number 89 of the House of Commons Standing Committee on Justice and Human Rights. Pursuant to the order of reference adopted by the House on June 21, 2023, the committee is continuing its study of Bill C-40, an act to amend the criminal code to make consequential amendments to other acts and to repeal a regulation. Miscarriage of justice reviews. Today's meeting is taking place in a hybrid format pursuant to standing orders. We have with us returning two witnesses. They've been here before. From the Department of Justice, we have Madame Julie Bessner, Avocate Conseil Secteur du
General Counsel, Law Section, and Legislative Services.
and Davis Ermith, Avocate Générale et Directrice par intérim.
Shannon Davis Ermuth, General Counsel and Interim Director.
40, and we were on clause 2.
Just a quick point of order, Madam Chair. I'm not going to. Yeah. No, I don't want to be. I'm not going to belabor this point because we did discuss it a little bit. But I just want to draw the committee's attention to the notice of motion that we had inviting the minister here. We agreed to it on November 28th. It was actually a notice of motion that I made, so it's no wonder it makes so much sense to me here. But it was that the Minister of Justice appear no fewer than 2 hours regarding the supplementary estimates B 2023-24, and that this meeting take place as soon as possible and no later than December 7th. So at this committee, we very rarely have unanimity. And this was a time where we actually all agreed to this. So I know we talked about it last Thursday. It's just that here we are again, and the notice of the meeting came out, and I saw that once again we were on C-40 and the minister was not appearing. So I do raise that. I still think there's a compelling reason why we would want to hear from the minister. I know that his time was reduced from 2 hours to 1. Maybe we could have a 2-hour meeting with the minister, but we had said no later than December 7th. It was scheduled for December 7th, and now here we are sometime later and still no minister. So I'm not, if you have anything to say on that, Madam Chair, I think I know what you're going to say, but I would be remiss if I didn't mention it because here we are again. And the motion said the earliest possible opportunity, and the minister's not here. But I think you'll probably say something.
So thank you, Mr. Moore, as the Vice Chair of the committee, and on behalf of all of your caucus, because I don't expect, and I will not entertain this again. I've already ruled on this point. I have absolutely nothing more to add. I've made my decision. My decision stands, and that is it, and I will not entertain any more points of orders on that, and I'm going to move to clause 2.
Madame la Présidente.
Mr. Fortin,
Oui.
if it's on this same point,
Absolutely not.
perfect, because I wouldn't want you to waste your time.
Vous savez, quand j'interviens en ce comité, c'est très rare.
I rarely intervene at this committee, but it's always for the same thing. We have two colleagues joining us by video conference, and I was wondering if everything has been done and whether everything is satisfactory. Thank you very much. Well, no, the two colleagues that are online are there strictly to vote if necessary, but they are not here to discuss the matter. The rules are such that they can vote by raising their hand. Well, I'm just concerned about the ears of our interpreters. There's so few of them, they're precious. I just want to make sure that our colleagues online agree that if they don't have the proper headset, they will not intervene.
Mr. Couric, please, yeah, clause 2.
Thank you very much, Madam Chair, and I'm pleased to have the opportunity to come back before this committee to discuss such an important bill. And something that I'd shared before about how there are two sides to how we ensure that Canadians can trust our justice system. And when we look at specifically Clause 2 as we dive into this bill, but more specifically, more generally, rather, the fact that we have a system that requires a particular tension between the different branches of our government. And the justice system in particular demonstrates that very thing. Now, Madam Chair, I do, as all of us, we're honored to take our seats in the House of Commons. And when I first got elected, I of course, was given a space for an office here as well, as we all are. But one of the things, and I take this very, very seriously, and it's an important illustration that we'll get directly to the subject matter related to Clause 2 here. But I think it bears mentioning that I can sit in my desk and I can look out one window and I see the Supreme Court. And I look out the other window, and I can see the centre block of Parliament. And it reminds me daily about the tension that does in fact exist in our system between the different branches of government. And although I would, and possibly at another time, there's a host of things that can and probably should be said about the role of the Minister of Justice and Attorney General, those two distinct positions within the executive structure of our government. I won't get into that, but Madam Chair, I would just note, because it has a close relationship, I think, to what we are discussing here, that we have a certain level of disconnect, I think, that Canadians are feeling when it comes to their ability to be connected with and hold their government accountable. And the fact that it's disappointing that the Minister of Justice, who I'm sure would have lots to say about this particular bill, although he was requested to appear on estimates, we know that there is a great deal of latitude given during the discussion of something that is as important as estimates are. It's disappointing that that respect would not be garnered to this committee, especially when it comes to the important work that needs to be accomplished, whether that's through the instances where there's been a miscarriage of justice, whether that's the rising crime rates that exist across our country in a host of different categories, or whether that's in relation to the many other concerns within the justice system writ large, or the various elements of where the Justice Committee and its pretty wide sweeping mandate. You know, there's a number of committees in Parliament that are more general in nature, and I count it certainly an honour to be able to, as a duly elected member, to be able to join the discussion at different committees from time to time. But the Justice Committee is one of those committees where there is it has a particular impact. It's not specific to one segment of society, to one part of government, but truly has that very, very wide scope. And I think that's why it's so important. And as I mentioned, in close connection to the topic at hand, why I am so disappointed in the fact that the Minister of Justice either couldn't find the time or refused to find the time to come and testify before this committee and be asked questions. You know, there's that necessary, and why I referenced the where I sit in my office here on the parliamentary precinct, being able to see both the legislative branch and the judicial branch, and understanding that in Canada there's a close connection between the legislative branch and executive branch of our government. Dating back to the Magna Carta, when there was that distinction and the role of limitations placed upon the Crown, it's important that is something that is actively preserved in what we do in this place, and I find it very unfortunate. And we see that when the executive power
Point of order, Madam Chair.
Yes, Mr. Biddle?
I may have come to the wrong committee meeting, Madam Chair. I think this is a meeting on Bill C-40, which I think relates to
Miscarriage of justice.
miscarriage of justice. But we're talking about office placements, and this is a bill the Conservative Party supports. So I'm curious why they're filibustering it when there's wrongfully convicted individuals who seek justice, and there are individuals here who are lawyers, who have sworn oaths with respect to their various law societies to uphold justice, to uphold their oaths as members, not only as lawyers, but when they come into the political sphere, and to laugh as this is going to be filibustered, Madam Chair, is just disrespectful. So I'm wondering if I made it to the right committee room, because we're not talking anything about Bill C-40, and I was hoping the honourable member could get back to talking about Clause 2 of Bill C-40.
Thank you, Mr. Biddle. You definitely are in the right committee, although I question myself sometimes if I am chairing the right committee as well. But Mr. Courik, for the record, just to be clear, and I ruled on, and the minister is definitely willing to appear. The question is, C-40 needed to be dealt with first, and that is not something that it's something that the Conservatives are obviously taking their sweet time on to get us to finish so that we can have the minister here. So as soon as we're done that's not a problem, just to let you know. Mr. Moore.
Yeah, just on the point that, Madam Chair, that Mr. Biddle mentioned, and welcome to the committee, and it is indeed, he's in the right committee, and this is a committee that has done a tremendous amount of good work. So where Mr. Biddle is not a regular at this committee, I want to let him know that this committee, under the leadership of our chair, we work relatively well together at this committee. We have very fulsome debates sometimes, back and forth, making our points. Sometimes there's compelling arguments one way or the other, but Mr. Biddle would also know, through you, Madam Chair, that we are on Bill C-40. We did, not to revisit it, but you brought it up, the motion that we had to have the minister appear. That was deemed a priority because we set a deadline for that. We did not set a deadline for the completion of Bill C-40. So just for the awareness of Mr. Biddle, we had set a deadline that we wished to meet with the minister. We hadn't set a deadline for dealing with C-40. Bill C-40 is a tremendously complicated piece of legislation. How would we know? The wrongfully convicted in this country do have a process. The Minister of Justice is Mr. Arif Virani. There is a process that has existed in Canada for decades whereby a individual who has been wrongfully convicted or feel they've been wrongfully convicted or suffered a miscarriage of justice can avail themselves of the Department of Justice and through the minister make application for relief. So I don't want him to be under the illusion that nope.
Mr. Moore, please get to your point of order because we're, we don't want to. You're taking away Mr. Couric's time, and I now have a list of other members.
Madam Chair, I understand. It's just that Mr. Biddle's not a regular on the committee, so I wanted to give him a little flavor that this is a committee that works well together.
And I would agree with you for the most part.
And
yes.
I want my comments on that to be on the record because he may never be back here again. I don't know, but. So I'm bringing, I'll bring my point of order to a close, Madam Chair, but just to say that I don't want him to be under any illusion because he may not be familiar with the issue at hand, that there's a vacuum currently in this country. There is a process for those who are wrongfully convicted or suffer a miscarriage of justice. Thank you, Madam Chair.
Thank you. So I'm going to ask Mr. Couric to get back to Clause 2, please.
Yes, thank
And not in relation
thank
to
you,
whatever else in terms of ministers. I think we've settled that one last time as well.
No, I appreciate that that, Madam Chair, and welcome to Mr. Biddle, as much as I, also not a regular member of this committee, certainly appreciate, as a duly elected member, the opportunity to participate in items of discussion that are so important to the people that I would assume the people of likes the which we both represent. Now specifically, and I do want to just, if I could, Madam Chair, when it comes to the illustration about my office placement, because it has a very, very direct correlation here, and it's by happenstance or fate. But the fact that when I do sit in my chair, I have the opportunity to see the different branches of government in action. And the reason why I bring that up is because it has a very direct correlation in the work that we do here. So for Mr. Biddle's benefit.
Donc, pour M. Biddle, je dirais tout simplement que lorsqu'il s'agit de la tension qui existe et qui est nécessaire constitutionnellement afin que les choses se fassent correctement, notamment pour ce qui est de l'administration de la justice dans le pays. Il existe donc cette tension. J'ai parlé de la place de mon bureau, non pas parce qu'il est si spécial, même si c'est un honneur d'avoir la possibilité de représenter mes commettants. Je suis sûr que M. Biddle ne suggère pas que j'ai moins ma place que lui au Parlement.
I'm sorry, there was no interpretation into French.
Le problème, I think the French word for filibustering, so.
Oui, est-ce que c'est vraiment un...
Is it really a problem?
M'entendez-vous en français?
All right.
Things okay? Okay.
Mais on n'entend
Non.
presque pas.
Oui, tout va bien. Vous m'entendez maintenant?
Le son est très faible.
No,
The sound is very weak.
nor is
Ouais,
there
un peu.
is there English translation either.
Ouais, ben je le monte le volume, mais il est.
OK.
Oui.
Mais
un
il y a
peu.
quelqu'un là qui peut vous aider?
Point of order
Just
on
a
that
sec.
point.
Ah, une voix douce. Oui. Alors, j'ai une douce voix dans mon écouteur, Madame la Présidente, et ça devrait.
Allô?
Madam Chair, I do hear something in my little earpiece here, and it should work now. Thank you very much, Madam Chair. Mr. Fortin will now get the French interpretation.
Thank you very much, Madam Chair. And of course, one of the dynamics, and I won't get into the significance of a bilingual parliament, and I coming from an area where I actually didn't have the opportunity to learn French as a young person, which I regret. But I did take what they called French 13 via textbook in grade 11, and I may be able to understand a few words, but regrettably, it's certainly not something that I'm fluent with, but I have a great deal of respect for my French colleagues and Francophone Canadians and its role in the fabric of our country. But to the point, I was just getting to the point where the tension that exists between the different branches of government. And it is key on an issue such as this when it comes to the miscarriage of, misapplication of, and where there are wrongful convictions in Canada. Because if that tension doesn't exist, and it goes back to the very premise of our judicial system, where we have that ability to the presumption of innocence and the ability to have a fair trial. And it is key in this discussion because when that tension becomes misaligned, when it's either there's not enough tension and people are who commits crimes, serious or otherwise. It doesn't necessarily have to always even be the major crimes that often garner the headlines, but just when there's that lack of respect for the system in general, or when it comes to wrongful convictions, which is the other side of that coin. We have examples before us, and I'll get into a number of examples that I think are very important to get into the record. But we need to ensure that the tension that needs to exist is shepherded very, very carefully. And one of the things that I fear is, and the reason I fear it is because I hear from constituents often about how they are losing trust in our judicial system. In fact, a common sentiment, and I've referenced this in the House, and I'll reference again here, I hear from constituents often who say we don't have a justice system. We may have a legal system, but it's not a justice system. And I certainly suspect, and often this is in the context of examples where it's that the message about, soft on crime, the revolving door of the justice system, that sort of thing, where people may commit serious crimes and get out without consequence, or when you have a Crown prosecutor that is so overwhelmed that they can only focus on a few of sometimes the thousands of cases that sit on their desk. And I know we have a former Crown here as a member of this committee, which I'm sure could provide some insight into that. But there's a couple. I'm glad to hear that, because, of course, a great deal of respect for those who fulfill that important role. But I think that's where the wrongful conviction conversation is just as important, because we have that if that tension does not exist, there will be that erosion of trust, which erodes at the very building blocks of a free and democratic society. And that's, I fear, there's been some damage that has been done. And as I said, I'll get into a few examples of that. But further to that point, I think that we have to take seriously our job as legislators to make sure that we do everything we can to accomplish the tasks set before us, so that we have a justice system that can be trusted, that can be understood, that respects its role to ensure that we have a civil and just society, but also that we have the ability for consequences to be levied when they are needed in the course of the process taking place. So I found, Madam Chair, and I'll get into some of the conversations around the examples here in a minute, but I do just note this has been something that has garnered a massive amount of attention here in Canada and to our neighbours to the south, where there are examples where you have this misapplication and people being convicted sometimes of very, very serious crimes, and they are in some cases spend decades or lose their life. And what I would like to note is there is a interesting dynamic that has evolved with the onset of non-traditional forms of media. And the reason why I bring that up is it's and in some of the conversations we've had in a number of different issues before the House of Commons, we've talked about the democratization of information. And it speaks, I think, with real relevance to this, and specifically in Section 2, how it talks about subsection 696.71-1, and where it's and a few of the other aspects here where it talks about the processes in which when there is a miscarriage of justice, but the democratization of information through non-traditional forms of media speak to something that has
Point of order.
Yes, who said that? Yes?
Just me.
Mr. Yes?
Again, Mr. Couric is not talking anything about this bill. This clause relates to Section 679, sub 7 of the Criminal Code, and we're nowhere in the ballpark. I know Mr. Couric doesn't want to see anything passed. He talks about wanting there to be justice for those who've been wrongfully convicted, but the filibuster continues. He's not relevant, and I think if he keeps going on, you should move on the speakers list.
No, I tend to agree with you, Mr. Biddle. I too have my office in the Justice Office as well, Justice Building, and I do look at the branches of government, but I don't think I'm here to talk about that today. Yeah, if you're done for now, maybe I can move on to another speaker because I've actually got a list here.
Thanks, Madam Chair. And with respect, it's been a little while since I talked about my office placement, and I'm actually in the Confed building. But so it's so I'll leave that as it is, because I can tell that the committee is just excited to hear more. But look, it's that democratization of information that I think speaks to really what has been an evolution of awareness on issues like this. You know, I found it very interesting here. It was a number of months ago. I had a staff member who had shared with me a podcast that they were listening to. And what is
Point of order, Madam Chair.
Yes, Mr. Biddle. I was waiting for that actually because I know Mr. Currick keeps deviating a little bit too much here.
Mr. Currick isn't even pretending to talk about the legislation or Clause 2, and I think that perhaps we should move on.
I think he's pretending. Come on.
I'm not doing a great job of it. And so if he's not going to talk about Clause 2, I think we should move on in the speaking order, Madam Chair.
Thank you, Madam Chair, and I do find it interesting that Mr. Biddle seems to be intent on delaying the proceedings so that as I endeavored to get to the point that I think is so very relevant to the discussion, because what has led, I think, and I would suggest has had a pretty significant impact on us being able to come to the point where we're at, is that we have a ability for Canadians to engage on these subjects and in some cases learn a tremendous amount of information. And I just mentioned before the interruption that a staff member of mine who had been listening to a podcast about wrongful convictions and how there was it was because of a podcast that had led to a outpouring of support for somebody who had and kind of like a society-wide, or at least the audience-wide pursuit of justice, to not only see that somebody who it was suggested had been wrongfully convicted, but to have the real person face the penalties of the crime that had been committed. So I think that bears an important relevance into the conversation. Because if we, as lawmakers, we are responsive, whether that be through the electoral process or the correspondence that we hear through our daily work. But it's that responsiveness that speaks to where we're at. And one of the things that, although we've had and there has been a process for the misapplication and miscarriage of justice in this country before, one of the concerns that we had shared that we want to make sure that it applies in the right way, that it doesn't open up or overburden our already burdened justice system. But Madam Chair, I think that where it fits so carefully or so significantly into the process here is that we have the ability for Canadians to be engaged in these subjects in a way that probably has not existed. Now, I would just note when it comes to
Madam Chair.
the...
Mr. Currick's just putting together a series of words that are completely irrelevant to this. He's not speaking in any way with respect to subsection or to Clause 2, and I again request, Madam Speaker, since Mr. Currick is not relevant on this subject, that we move on the speakers list.
So I do understand that there's a lot of leeway. Apparently, when I came to this just a little over 2 years ago, here there's a lot of leeway that we give members. But I think there's a time when, and I think that leeway, it just sort of takes its course, and that we do need to move on. So, Mr. Moore.
Yeah, Madam Chair. So far this committee, I've listened to Mr. Currick speak about miscarriages of justice which is exactly the topic of this legislation. We're starting our study on Bill C-40. It is beyond any doubt, the rules are that a member has a tremendous amount of latitude when speaking at committee. That is well established. There's no doubt about that. Mr. Couric is not using that latitude. In my view, he's been narrowly focused on the issue at hand, which is Bill C-40, miscarriages of justice and wrongful convictions. He's not even using the latitude to which he could avail himself. So I commend him for staying on point, on topic.
Would you like
And-
us to take a vote on that, Mr.
and
Moore?
so-
See what
well,
members on the committee
luckily,
think?
that's not the process we live in. The world we live in, the rules that we have are that a member has a tremendous amount of latitude, cannot be limited in their ability to speak to legislation, and Mr. Couric is not at this point even using any of that latitude. But I will note that Mr. Biddle is a first-time visitor to this committee, and so far, he's used every opportunity to interrupt someone who is on, and delay, someone who's on topic, someone who's working his way to a point. And the longer he is delayed and the more interruptions there is, I would presume the longer it's going to take Mr. Couric to make his point. I'm curious to know Mr. Biddle's opinion on this legislation, and but to needlessly interrupt someone that's in the middle of doing their job.
Mais je pense qu'il ne faut pas interrompre quelqu'un injustement. Monsieur Biddle, s'il vous plaît.
Paragraph or so doesn't mean you're relevant to the topic, relevant to the clause, relevant to the legislation. Mr. Couric is obviously filibustering. If he's going to do it, at least pretend to be on topic, which he's not doing. As a new member to the committee, I wouldn't presume to filibuster here without any knowledge, any view of witnesses, any review of transcripts. Mr. Couric is just saying words that happen to include perhaps topics of subject here, but he should be speaking to the point, which is Clause 2, which is subsection 679 sub 7 of the Criminal Code. And I'd love to hear Mr. Couric talk about Section 679 sub 7 of the Criminal Code and how it relates to this bill. And if he wants to filibuster, he can filibuster it that way. Otherwise, the chair has the authority, because he is abusing this matter of relevancy, and to move on the speaking list.
So, by Mr. Couric's own admission, he was not a member of the committee when we actually heard testimony and evidence and witnesses appeared on the bill. No, but fair point. Not just right, but I do appreciate the order that he's raising, because I believe it's a valid one. And I'm ordering that we now move on to the speaker list. I believe we've exhausted the different words that you've said about, many times over and over again. And there is no
point of
amendments on
order.
Clause 2 either.
Point-
So if
Point of
you
order,
could,
Madam Chair.
you could put an amendment if you wish,
So point of
but
order,
there
Madam
are no
Chair.
amendments on Clause 2.
I appreciate the discussion that has been undertaken here. However, as a duly elected member and as somebody who is subbed into this committee to participate in an important discussion, I would suggest that removing my ability to intervene on the speaking list comes awfully close to a violation of a member's privilege. I'll leave that for the moment, but on the point of order, I am a little bit concerned on this issue larger than that, because what I've been talking about has a direct connection to the historical precedent that has led us to the point that we're at in the discussion surrounding C-40. So with all due respect, Madam Chair, and if you are making a ruling that would violate my privilege as a member to be able to intervene meaningfully on this subject, I would just urge you to be very cautious in that, because I certainly wouldn't want you to inadvertently violate a member's privilege when there is a very close connection. And had it not been for the many interruptions, and Mr. Biddle talks about filibuster, well, his word count in this committee is certainly not not small, just in the course of him taking the time to delay the proceedings on the discussion that we are having at hand. I would just urge careful consideration, because I think that it bears very both clear relevance to the discussion at hand, and wouldn't want a member's
order,
privileges to be
Madam Chair.
violated.
Let me just rule on what he said.
That's coming awfully close to a threat. to the
And
chair.
I don't take
And I think
threats lightly.
the chair is very capable of making a decision. Threatening her with that is inappropriate.
So I usually am very cautious in whatever I do, particularly when I'm sitting on or chairing committees, whether it's in the House of Commons or anything else I've done in the last number of decades in my career. I said you can go back later, so I'm certainly not removing your right to speak whatsoever. What I am ordering, and this will be the last time, I intend to enforce the rules, and I believe you are being irrelevant and repetitive. I am saying, and I am warning, that if you are risking one more time, if I direct you to discontinue with the speech, then I will move on to another member, and you can get back again on the order of speakers if you wish. That is it. And I can give you the page number for that if you wish, and the chapter and the book.
Thank you.
Yeah.
Thank you very much, Madam Chair. So look, when it comes to the ability for Canadians to be engaged on the subject, and I think that part of the reason why we have this before us is because we have examples like the wrongful conviction of Donald Marshall Jr. and the role of racial bias that was a significant part of what led to a 17-year-old Indigenous boy to end up being wrongfully accused of murder, and was subsequently convicted and incarcerated for more than a decade. And I think that in the case of Mr. Marshall, and as I've done some research, and contrary to what Mr. Biddle is suggesting, there is the passion of Canadians to engage on this subject, and that democratization of information, specifically with things like podcasts and internet sites. There's the ability for people to coalesce and build communities and find support. So that I think speaks to directly the issue at hand. So I will, Madam Speaker, just because I do want to ensure that my colleagues can have a chance to engage on the subject as well. But I would just, in the case of the wrongful conviction of Mr. Marshall, we have an example here, and I know representing, as was referenced earlier, my constituency is Battle River Crowfoot. Both the Battle River, which was known to be the location of a series of battles that took place between different Indigenous tribes throughout history in memorial, and Crowfoot, named after Chief Crowfoot, which was a legendary Indigenous leader on the plains, and certainly the issues. I'd have a lot to say about him and the legacy that he has left in the creation of the modern Canada that we have here today, and especially some of the role that he played in the negotiations of treaties and what that looks like for the creation of the country that we have here today. But I would just note that in the wrongful conviction of Mr. Marshall and the role that racial bias played in that, it was found that there were systemic failures that contributed to Mr. Marshall's wrongful conviction, and that as we see today, not seen at the time, which led to this wrongful conviction and a miscarriage of justice, and speaks to a breakdown in that needed tension that I referenced earlier. So when it comes to whether it's the example of Mr. Marshall, and I can get into a few more, and I would note that the Marshall Inquiry, it was the government of Nova Scotia had appointed a royal commission to investigate the errors errors that had occurred in Mr. Marshall's case, known then as the Marshall Inquiry, and asked for recommendations to ensure that similar mistakes could be avoided. The Marshall Inquiry identified errors at virtually every stage of the process that included things that I would note. Responding police officers had failed to search the area and question witnesses. The investigating officer held a known racial bias against Mr. Marshall. And I won't read into the record one of the quotes there because it certainly has some very, very strong language, and I wouldn't want to bring disorder here. The Crown prosecutor had failed to interview witnesses that gave contradictory statements and to disclose these inconsistencies to the defense. And Mr. Marshall's defense counsel did not interview Crown witnesses and failed to ask for disclosure of the Crown's case. And the officers who investigated the case in 1982 improperly pressured Mr. Marshall to falsely admit that he had attempted a robbery, and the Court of Appeal used this statement to suggest that Mr. Marshall was partly to blame for his wrongful conviction. So to summarize this as an example that relates keyly to the overall conversation, I would suggest, Madam Chair, that we take very seriously, we look at some of these issues, and we make sure that in the process of the discussions that we have before this committee, we ensure that we find the right tension, because we cannot allow the system to be bogged down with nefarious complaints of people who were convicted under for breaking the law, whether that be serious crimes or whether that be simple and nominal things. But at the same time, we need to ensure that when there is miscarriages of justice, because as to err is to be human, as is so often said, Madam Chair, it's so important to find that tension. So with that, I would cede my time to the next speaker, but I would ask, Madam Chair, to be put on the list, and I know that I look forward and I hope that Mr. Biddle will pay very close attention to the further meaningful interventions that we have, whether it's on such important examples as I've just referenced, or the many other pieces of this that speak to the importance of us getting this right to maintain that tension that needs to exist within the administration of justice within our country. Thank you, Madam Chair, and I would ask to be put back on the speaking list. Thank you.
Thank you. Mr. Garrison?
Thank you very much, Madam Chair. I actually want to speak about Section 2 of the bill for a moment. There's nothing mysterious or controversial in Section 2. Section 2 simply says those with an application before the new commission are subject to the same rules about release or detention as those who have an appeal pending. Very straightforward, not difficult to understand, not controversial in any way. So why are we spending so much time on Clause 2? I want to talk about it just for a moment because I think it's important that we proceed. So we're spending so much time on Clause 2 because one party has said that nothing will pass this Parliament until the carbon tax is removed. This has nothing to do with justice issues, and it's the first time while I've sat on this committee, or I must say previously when I sat on the Public Safety Committee, where other political agendas have stopped the work of the committee. It's quite legitimate, I think, for people to spend hours and hours talking about justice issues, but when they're doing it for a different political purpose, it makes it very difficult for this committee to remain collegial and to for people in the public to accept that there's goodwill here to attack what is a very important issue. So why do I think it's important that we need to move on quickly? Mr. Moore said we have a process for miscarriage of justice. Yes, we do, and all parties agreed it's faulty. And when you look at who succeeded in getting a successful review of their case under the existing system, there's something like 20 cases over the past 10 years. One of those was Indigenous, one of those was Black, and none of those were women. And when you look at the overrepresentation of those groups in our justice system, there's clearly a need for us to make this reform that Bill C-40 proposes. And the way that's related to Section 2 is there are people in prison right now who have been unjustly convicted who are waiting for a release that this bill and this section would provide if their application was accepted. So another political agenda, another statement by the leader of the Conservative Party that nothing will happen here is actually keeping, in particular, Indigenous women in jail longer. And so the sooner we can pass this bill, the sooner we can start to address those systemic injustices in our system. Nothing controversial, nothing difficult to understand in Section 2. If people in the clause-by-clause process want to raise general questions, there's a time for that. At the end, we say, should the bill pass? They can debate that. I'm from a rural area till the cows come home. Under that, there's breadth in that. But under Section 2, there isn't that breadth. And I'd urge members to stick to the topic at hand, which are the clauses we're going through. And when we get to should the bill pass, fill your boots filibustering if that's what you think you need to do. But what you're actually doing is keeping people who've suffered miscarriage of justice in jail longer.
Thank you, Mr. Garrison. Mr. Van Popta?
Thank you. I will talk about Clause 2, Section 679.7 of the Criminal Code, subsection 7. And at our meeting last week, Ms. Besser, you were very helpful in pointing us to the Vavilov case, which I had not, I wasn't aware of it. So I looked it up and read some summaries of it. It's a Supreme Court of Canada case, quite recent, so I even forget the year that it was. But it's a judicial review case. And in the Vavilov case, the Supreme Court of Canada held that decisions about judicial review, and we're talking about, you know, reviewing a decision of either the Minister of Justice under the current legislation or the commission, which will be established by this legislation. So in the Vavilov case, the Supreme Court of Canada held that decisions should be presumptively reviewed on a reasonableness basis, except in 5 separate and discrete exceptions. And this is the important part of the Vavilov case. Number 1, cases where the correctness standard is required by law, right? The correctness standard being the higher standard. Cases, number 2, cases where the statutory appeal mechanisms are in place. So in other words, you can still appeal to the Court of Appeal. Number 3, constitutional questions. Number 4, general legal questions of central importance to the entire legal system. And number 5, questions regarding the jurisdictional boundaries between administrative bodies. But for one of those categories, the reasonableness standard applies. And so anyways, I did a little further digging, and I found a couple of really interesting cases, one called Walchuk and the other called Bouchard, both predating Vavilov. One was a federal court trial decision, and the other was a federal court of appeal decision. And they both upheld the reasonableness standard for the criminal conviction review group as it is currently existing under present legislation under the relevant sections of the criminal code. So I thought I would take a look at those cases because clearly they're going to be very important to the way the new commission is going to operate. Because in each one of these cases, the applicant is asking for a review, is asking for the commission to review their case, their fact situation, and they're going to be arguing that that there's been a wrongful conviction and a miscarriage of justice, and the remedy that they would be seeking from the commission is that this would be then ordered back to a trial or back to the Court of Appeal, which is ever is a relevant one. So my question the other day and today that I'm looking at is, what happens when the commission makes a decision that the applicant is unhappy with, you know, turned down? So I looked up a couple of cases. The first one is from this federal court trial decision of 2018. Jean-Claude Bouchard applied for review by the Minister of Justice, who at the time was Jody Wilson-Raybould, so fairly recent. And here are the facts, very interesting. One of the beautiful things about studying the common law is that we get to read stories about people's lives, and that's the way we learn the law. So Mr. Bouchard had served 26 years for the murder of a Robert O'Brien, the murder having taken place in 1979 in Montreal. But Mr. Bouchard always maintained his innocence. He was convicted by a jury on June 23rd, 1983. On June 19, 2015, so that's some 22 years later, now on parole, Mr. Bouchard applied for a review of his case pursuant to the existing section 696.1 bracket 1 of the Criminal Code on the basis that a miscarriage of justice had occurred in his case. Bouchard submitted 2 affidavits in support of his application. The first affidavit was one sworn by a Gilles Bernard, who confessed, quote unquote, confessed, that he was indeed the murderer and that Mr. Bouchard was not. And then the second affidavit in support of Mr. Bouchard's application before the then Minister of Justice was one sworn by Gilles' son, Alexandre, who confirmed some of the facts in his father's affidavit. It would seem like a slam dunk case. Somebody else is confessing to the murder. He didn't do it, I did it. But here's the rest of the story. Bouchard and Bernard had met at a halfway house in 2011, both having served their time inside and now transitioning to life on the outside, and they discussed their personal lives and their fact situations and the reasons for their imprisonment. Now, and here, this is a very important fact, Bernard died of cancer on May 11, 2012. And 2 days later, Innocence McGill, so this is a group of volunteers working out of McGill Law School, received a package containing his affidavit that he had sworn 4 months earlier. So you can immediately see why the Minister of Justice starts to become a little bit suspicious. Go, okay, here's an affidavit from somebody who knew he was dying and didn't release it. You know, clearly he had given instructions to somebody to pop this in the mail the day I die. 2 days later, the Innocent McGill people received it. So, but, you know, they're doing their job, and they interviewed Bernard Jr., the father of the deceased person. And on February 4, 2014, so this is like 18 months later, he signed affidavit number 2, confirming a number of the things that were in his father's affidavit. The Montreal police conducted a new investigation, but it's many, many years later. The trial had gone cold. Not a lot of new evidence was available. So the Minister of Justice rejected the application on the basis that the affidavits didn't meet any exceptions to the hearsay rule. And without new evidence, there was no reasonable basis to conclude that a miscarriage of justice likely occurred. Now, the Department of Justice had considered whether there was new evidence admissible, and the federal court tried the decision on their judicial review application hearing, reviewed the work that the Minister of Justice had done. And I just want to read a couple of paragraphs. Right, so this is the Federal Court Trial Division speaking on the judicial review application. Quote, the representative, and that would be the representative of the Department of Justice of the Criminal Conviction Review Group within the Department of Justice, that representative also considered Palmer versus the Queen, a 1980 case from the Supreme Court of Canada, which held that new evidence is admissible on appeal when, and then 4 things. Even by due diligence, it could not reasonably have been adduced at trial. Well, obviously, the affidavit was sworn many years later. Number 2, it is relevant. Number 3, it is credible in the sense that it is reasonably capable of belief. And 4, if believed, it could reasonably have taken, with the other evidence adduced at trial, to be expected to have affected the result. So clearly the court found that the Department of Justice had given due consideration, and that the Department of Justice had found against Bouchard for a review. Bouchard applied, of course, for judicial review, and that's the case that we're talking about here today. And this is a question that the way the federal court posed the question, or that it was posed for them. Did the minister err in finding that Gilles Bernard's statement, they're not even calling it an affidavit, statement constituted unreliable and inadmissible hearsay evidence that offered no reasonable basis to conclude that a miscarriage of justice likely occurred when the applicant was convicted of murdering Mr. O'Brien? That's the question that is set to be answered. The question then is, what is the standard of review? Well, paragraph 34, the standard of reasonableness applies to the issue raised in this application, citing Walchuk, which I'm going to talk about in a minute, which was a 2015 Federal Court of Appeal decision. So thank you for, Madam Besner, for pointing us to the Vavilov case. That is good law, of course, but I don't think it overturns the Bouchard case, but only confirms it as being good law. The reasonableness standard is what's going to apply. Now, the federal court looked at the legislative framework within which they were to work to review how they were going to answer that question. Paragraph 35, it is helpful to recall the legislative framework within which the minister is to assess an application review based on an alleged miscarriage of justice. First, quote, any remedy available on such an application is an extraordinary remedy. That is the law today. It may change when Bill C-40 passes, but that is the law today. In making a decision under subsection, the relevant section, the minister is to take into account, quote, the relevance, the reliability of information that is presented in connection with the application. And when the preliminary assessment has been completed, the minister dismisses the application without an investigation if, quote, she is satisfied that there is no reasonable basis to conclude that a miscarriage of justice likely occurred. So that's how the federal court is analyzing the legislative framework within which they are to do their judicial review. So their finding is this. Should come as no surprise. The minister is satisfied that there is no reasonable basis to conclude that a miscarriage of justice likely occurred since the new evidence adduced by the applicant is not reliable and does not meet the admissibility criteria for hearsay evidence as set out in the Kellowan case, which I have to admit I did not read. I'm of the view, the trial court says, that the minister could reasonably reach that conclusion and that her assessment of the record is among the possible and acceptable outcomes that could be justified on the basis of the facts and the law. So that's the way the reasonable test works. The judicial review judge looks at the work that had been done by the administrative body and said, is it reasonable? I might have come to a different conclusion, but I can see that it is not unreasonable that she came to that conclusion. Just a couple of other citations. The minister did exactly what the applicant argues was required of her. Consider whether it was more probable than improbable that Gilles Bernard told the truth in his affidavit. The minister's answer to that question was in the negative, and that is a reasonable answer if all facts of the case are taken into account. So I find it interesting. That's really the balance of probability test that Mr. Curtis told us about at committee. Mr. Curtis, you'll recall, was the representative from the UK Criminal Conviction Review Commission. And we asked him questions, so what does it mean, likely or you know, reasonable probability or whatever? And he said, well, it's you know, it's not fanciful. It's got to be more than that, but it's not proof beyond a reasonable doubt either. And he says it's somewhere around the balance of probabilities, probably a little bit below that, below the civil standard. And I find it very interesting to read. I'm going to read it again because I think it.
Point of order, Madam Chair.
Yes, Mr. Garrison.
I commend Mr. Pavlov for actually talking about the bill and things relevant to the bill. However, he's actually talking about a different section. We're doing clause by clause. So he's talking about the section which the Conservatives have sought to amend, which deals with the bar by which a miscarriage of justice is found to have occurred. That occurs in clause 3 on page 4 of the bill. We're, unfortunately for him, talking about clause 2 and an earlier page of the bill. So I would ask the chair to consider that. And in fact, when we come to the Article 3 in question, I would wonder whether Mr. Van Popka would not be in danger of not being able to make that argument under the proper section because he's already done so under this section.
I find it, what I'm talking about is highly relevant to what we're talking about. I had asked a question of our witnesses the other day what would happen if an applicant is unhappy with the decision. And I was pointing to the Vavilov case, and I've done my research, and I'm just want to confirm that I think that that is exactly the right answer. So I don't know. I'll see what happens when we're talking about Clause 3. I'll have other things to say about that as well. So anyways, I want to move on now to the Walchuk case, which is actually a Federal Court of Appeal decision, which is 3 years before the Bouchard case that I was just referencing. And here's the summary of the Walchuk case. Again, this predates the Vavilov case. So on June 14, 2000, Walchuk was convicted of second-degree murder of his estranged wife, Karine. It's a very sad story. Walchuk applied for ministerial review on the grounds of a miscarriage of justice. The Minister of Justice at that time was Rob Nicholson. His application was rejected. He applied to the federal court, and that was rejected, so now he's appealing to the Court of Appeal. That's what's happening here. So here are the facts. I'll try to be brief. It's a very sad story.
Yes, Mr. Garrison.
This example has the same problem as the last. It's not about this section, which is before us. It's not about Clause 2. It's actually about Clause 3. And so I know I'm being a bit picky here, but since it's going to take us seemingly forever to get through this bill, we could at least try to have the arguments made under the clause we're actually considering or saved for the clause that's coming up, which they are relevant to. And that question is whether or not it should be accepted as a miscarriage of justice. That is in Article 3 on page 4 of the bill and not in Clause 2.
So as the chair, I want to ask staff for a little bit of guidance based on what you've heard. No, I mean, no, not officials. I know I have full authority as the chair to rule on relevance and on duplicity and so many other items, but based on the laws and the arguments that are made and the clause, do you have any legal opinion on what he's been going on with, whether it's directly related to Clause 2 or not?
Point of order, Madam Chair.
Do you have a point of order on me asking staff the question?
Well, I don't know that, when you say staff, I thought you were talking about your table.
I meant Department of Justice
The
staff.
department ruling on relevancy, that would be up to you, but I don't know that putting them on the spot as to, I know Mr. Van Popta anchored his, I thought, very interesting comments on Clause 2. He spoke directly from Clause 2 and some of the, and then brought in some relevant case law that had come from our previous meeting. So, you know, it's probably fair to ask departmental officials to comment on the question, but I think isn't it to Mr. Van Popta to put the question to them based on what he's been saying, rather than.
Yeah. No, fair point, Mr. Moore. I would have hoped that Mr. Van Popta did put some questions to the officials, but I guess that's not going to happen. So I'm going to listen again to your point of order, Mr. Garrison, so that I can fully be able to make a ruling on this and move on.
And so I am not disputing whether Mr. Van Popta's comments are about C-40. They are. But the section, Clause 2, is about whether someone should be detained or released while their application is being considered by the Commission. And what Mr. Van Popta's arguments are about, and quite rightfully, are about what's in Clause 3 of the bill, which is about what is the standard by which we decide that a miscarriage of justice either may have occurred or may not have occurred. So I'm simply pointing out that the cases he's citing and the things he's talking about have nothing to do with detention or release while awaiting a decision of the Commission. They have to do with something further on in the bill. I'm not arguing they're irrelevant to the bill. I'm just saying that since what we're facing here is a filibuster, we can at least filibuster under the right clauses.
Yes, yes.
I will concede the point, but I reserve the right to talk about the Walchuk case when we do get to clause 3. But I do have another question
Yes, of course.
for the official, for Julie Besner or Shannon Davis-Ermuth. So in preparing for this study, I read up quite a bit about the David Milgaard case, because that's what it's called. It's called the David and Joyce Milgaard case. And so just, and I'm not going to belabor it, right, but just because I'm assuming that everybody is at least somewhat familiar with this case. Mr. Milgaard served 23 years for a crime that he didn't commit. There was no, right, this is one of the reasons that why we're talking about why we've introduced C40, because the process for seeking justice when one feels they've been wrongfully convicted is very awkward under the criminal conviction review group process currently existing in the criminal code. So rightly, we are trying to amend that. And this is the way it finally got to the attention of the Minister of Justice, who, by the way, was Kim Campbell at the time. Credit goes to Joyce Milgaard's persistence. Joyce was a mother. One day in September, and so I'm just reading from a section from a speech that I gave in the House. So these are my own words. Credit goes to Joyce Milgaard's persistence. One day in September 1991, she held a vigil in front of the hotel in Manitoba where Prime Minister Mulroney was scheduled to speak. She didn't actually expect to speak to the Prime Minister, but he walked over to her to hear what she had to say. Years later, in an interview with the Winnipeg Free Press, the Prime Minister had this to say. I think it's just a great quote. There was something so forlorn about a woman standing alone on a very cold evening on behalf of her son, but in that brief meeting, I got a sense of Mrs. Milgaard and her genuineness and her courage. We all have mothers, but even the most devoted and loving mothers could not continue their crusade for 22 years if there was any doubt in their mind. So I went back to Ottawa and I had a much closer look at it.
Point of order.
I told I'm getting to,
Point of order.
we're talking about the
Point of order.
Yes, yes, Mr.
I don't know if there's a question coming, but it's the height of irony to be quoting from members of the Milgaard family while filibustering this bill that is going to prevent people from seeking access to justice who are wrongfully detained. I'm sure there's a question coming, but I hope the honourable member knows how ridiculous and hypocritical it is to be invoking that name, invoking that comment, and use it to filibuster this committee. It's appalling.
Madam Chair, on that point,
It's ridiculous.
Mr.
on that point, just to be 100% clear, and I don't want Mr. Van Popta to lose his train of thought or his spot, and if he might even want to back up a few steps, but my understanding is Mr. Van Popta was quoting former Prime Minister Right Honourable Brian Mulroney, and in my mind this ties back directly to Clause 2, which says that this section applies to the release or detention of that person, as though that person were an appellant in an appeal described in paragraph 1A, pending the completion of the review, pending a new trial. We're talking about the wrongfully convicted or a situation where there's a miscarriage of justice. Mr. Van Popta is speaking very clearly and solely on those issues, and the issues he's raising relate directly to Clause 2 of Bill C-40, which involves the custody of an individual who has made application under these provisions. Previously, prior to C-40, C-40 has not come into effect. We don't know the outcome of these deliberations that we're having. There's several amendments that we're going to get to on C-40, some by the NDP, some by the government, and one by ourselves. The Conservatives have moved one amendment, but this goes to the core of what we're talking about here. But I want to be very.
Yeah, point of order, Madam Chair.
It is a point of order, Madam Chair, because Mr.
I
Van
didn't know if you were
Popta.
trying to sort of skip the line.
No, I'm not. I just want to.
Because you are on the list.
Because the point was made. in error. There's two
I
errors.
hear you, Mr. Maloney.
One
Let's
is
give
that
Mr. Moore another minute.
what Mr. Van Popta was saying wasn't relevant when it is 100% relevant. Two was that he was quoting the Milgaard family when in fact he was quoting, if we listen carefully, which I was endeavoring to do, I believe he was quoting the former Prime Minister Mulroney. Now, I stand to be corrected, and I would ask Mr. Van Popta to clarify, but I understand he was quoting Mr. Mulroney, and the impression that he had upon meeting the mother of someone who was wrongfully convicted and who had been advocating for their son for 22 years. So that's it's on that point of order, Madam Chair.
Mr. Maloney?
Thank you, Madam Chair. A number of times today we've heard from opposition members that this is a good piece of legislation. It's ironical and hypocritical. It's ironic and hypocritical at the same time. In February, I will celebrate 28 years as a member of the Law Society in Ontario. When I became a lawyer in 1996, I took a number of oaths. One of them was to act in the best interests of my clients. One of them was to do everything while preserving the integrity of the justice system. We have an opportunity with this piece of legislation to fix something that many, many people, as Mr. Garrison has referred to earlier, are anxiously, desperately awaiting to fix. To invoke the family name Milgaard while sitting here, this is now the third meeting filibustering this piece of legislation because their leader, Mr. Poilievre, has stated publicly that he has no intention of passing any legislation before the end of this session is outrageous. These people are waiting in prison. Their families are waiting patiently. They should be ashamed of themselves. Remember, on the other side are lawyers themselves. There is no excuse for this, Madam Chair. I'm prepared to sit here today, tomorrow, and the next day, and as long as it takes to get this bill passed, because it is important and these people deserve it. Thank you, Madam Chair.
I have celebrated over 32 years as a member of the Bar of Nova Scotia, and I too took oaths to uphold the law. When Mr. Currick spoke about Donald Marshford Jr., I was still a law student at that point. So I recall vividly the Royal Commission and various things. So I take this very seriously, and I'm sure all members here do. So in light of what we are all hearing, I believe we all do take this very seriously, and we're not here to harm people who have already been harmed enough. I would suggest that we stick to relevant points, avoid duplication, and just let's get on with it as much as we can. Clause 2, there's not much in there. We've already gone over Clause 2 over and over again. Was there any other points anybody wanted to do on the odor, whatever it's called here?
Madam
Before
Speaker,
we get back to the...
I was just about to ask my question to the... I said I had a question.
but I have Monsieur Fortin.
Oh, sorry.
Merci, Madame la Présidente.
Thank you, Madam Chair. I've been a member of the bar for years. I'm not going to tell you how many because you'll know my age, but I think that we're about the same vintage. I'm very concerned about this because I listened to Mr. Maloney, and normally I don't agree with him, but right now I think he is saying something important. I agree with him. The problem that we have here is not that it is the Conservative members of the committee that do not want to adopt this bill. It's their leader. I mean, sure, we could sit until next week, day and night, but we're not going to get anywhere because they have strict instructions to not pass this bill. So there are two possibilities. Our Conservative colleagues talk to their leader, or the Liberals talk to the Conservative leader. I mean, we can beat our heads against the wall here for days, if not weeks, but we won't get anywhere. Would it be possible for one side or the other to have the leader of the party, Mr. Poilievre, see the light? Because that's where the problem lies. It's not with each of these members here today, with whom I have great respect. I think that it really is that problem. I think we're wasting our time here, and we're wasting our witnesses' time as well. What is really awful is that, as Mr. Garrison said earlier, and Mr. Maloney said, their families waiting for their children to get out of prison, and all they are getting is this type of, well, I wouldn't call it indifference, but this useless filibustering from one individual who decided to block the proceedings and progress of the House. Unfortunately, we are a prisoner of that individual.
Merci, Monsieur.
Thank you, Mr. Fortin. My concern is to continue with this meeting, continue with clause-by-clause study, and to find a resolution.
Speak on the clause. Mr. Van Popta, you were... Yes.
I said I have a question for
You do,
Ms.
you did.
Besner, and I really do want to get to it.
Please go ahead.
And I will get to it shortly. I'm not trying to prolong things at all. And indeed, I was quoting Prime Minister Mulroney, not the Milgaard family, but and he's speaking with a great deal of deference for Mrs. Milgaard. So I don't know how any of this can be offensive. This is what he said. But in that brief meeting, I got a sense of Mrs. Milgaard and her genuineness and her courage. I don't know what's offensive about that. Here's my question. The file was, Prime Minister Mulroney put the file back to the Minister of Justice, who I believe was Kim Campbell at the time, and she reviewed it, and she found that he had a case, that Milgaard's application was valid, and she ordered a new trial. But the Saskatchewan Attorney General decided simply to enter a stay of proceedings. Now, later on, right, there was DNA evidence, and he was exonerated, and he actually got a reward, I think, of $10 million. But in that intervening period, here's my question. Under Section 7, revised, which is in Clause 2 of Bill C-40, how would Mr. Milgaard have been dealt with at that time when he was in this sort of state of suspension where the Saskatchewan Attorney General just decided to enter a stay of proceedings? But he had not been found not guilty, not found innocent, not exonerated, just no more proceedings against Mr. Milgaard.
I know, I just need a moment. So in the Milgaard case, when the Minister of Justice initially refused, dismissed the application, and then his mother approached the Prime Minister. After that, there was a reference sent to the Supreme Court of Canada, and the Supreme Court looked at the evidence, heard from a lot of witnesses, and it, in its decision, recommended to the minister that it could be referred back to Saskatchewan for a new trial.
That's what happened.
So when it's referred back for a new trial, under the common law, I think the Superior Court in Saskatchewan would have had the authority to determine whether Mr. Milgaard could be released or detained pending that new trial, but it didn't get to that because there was a stay that was entered, as you pointed out. So 679 deals with release pending a review or release after the commission in the future makes a reference for a new appeal or a new trial, that the Court of Appeal is the court that should hear that application for release. And I think I articulated the test is the same thing as if it were a conviction appeal.
Thank you.
Is there anything I can add?
Thank you.
Thank you. I have no
Thank
further
you very
points.
much.
Thank you.
Mr. Caputa? Caputo.
Prepared to cede my time to Mr. Moore here.
Yes, he's next. Mr. Moore?
I think the question I have can wait. It's, it covers a couple clauses, so, yeah, I'm good.
You don't have a question?
I already asked it.
Okay. Mr. Couric, you were on the list.
Yeah, thanks, Chair. And I do have a number of questions, but just in light of some of the ongoing conversations here, and I know I will have some statements about the case of William Napus that I think bear relevance to a number of sections, including Clause 2, but it can also be, those questions I think can also be raised in some of the subsections in Clause 3. So I'll cede my time.
Thank you. I have no one else on the list, so I'm going to ask if Clause 2 carries. Yes. Okay, thank you very much. Clause 2 is carried. I will now move to Clause 3, and I'm going to ask if a member wishes to move the clause they put forth. With the amendment. Sorry, amendment of the clause. Mr.
Thank you, Madam
Garrison.
Chair. I believe that NDP 1 is the first amendment to be considered in this
That's
clause.
correct.
So, as C40 stands, the bill requires applicants to the Commission to have exhausted all their appeals before their applications can be accepted. And as we heard almost universally from witnesses before this committee, this potentially excludes applicants from applying who are the least likely to have been able to have either the resources or the ability to mount such an appeal. And so what this amendment proposes to do is what was suggested by the Canadian Bar Association, is to create an exception. It's not to say that anyone can appeal to the Commission whether or not they've appealed. What it says is that if the Commission takes into account factors that have constrained the ability or the opportunity of the applicant to file an appeal, they may accept the application. So this does not open the doors wide, but it allows people to make an application who may have not have had adequate legal advice, may not have known the process, may not have known the deadlines for filing appeals, and therefore miss their chance to appeal. All those kinds of factors which someone who is marginalized, racialized, indigenous, or poor is very unlikely to have the skills and abilities to understand how to make that appeal, and legal aid quite often is not available to those people in many provinces who are in that situation. And so what this does is say the purpose of establishing the new commission is to make sure we catch all of those people who may have suffered a miscarriage of justice. And among those are those who may not have been able to file an appeal. And so this creates a narrow exception under the authority of the commission to accept an application where they believe that those people who are most marginalized in general may not have had the opportunity to file an appeal. And so I know there have been some references to concerns about opening the door to everyone applying to the commission. This amendment does not do that. It creates a limited exception, and it gives the commission the authority to decide if it feels the case meets the criteria which they set for this exception. And so I believe, again, as we heard from almost all the witnesses on this bill, that this is an important improvement we could make to the bill without affecting the ability of the new commission to consider cases and without throwing the doors wide open to those who may not have had a good case at all, as sometimes referred to as the faint hope people, and actually focus on what we're trying to do here is make sure that we correct systemic miscarriages of justice where people lacked resources and lacked ability to defend themselves against the miscarriage of justice. So thank you, Madam Chair.
Madam Chair, I'm not going to discuss the substance of this, but if I understand correctly, if we adopt a NBDP 1, then Liberal 1 falls, right? Yes, that is exactly the case.
Let me just say, first of all, how glad I am that we're getting to actually talking to amendments. So I want to thank my colleague Randall for this amendment, because I agree with him. Lib 1 is drafted to essentially do a similar
Not
type
sure
of
what
thing,
he's
but I
talking
prefer the way
about.
Lib 1 is drafted. Lib 1 actually makes it clear that the same criteria will apply to cases that weren't appealed to the Court of Appeal in the same way that if they weren't appealed originally to the Supreme Court. So
So can I get a clarification? You're talking on the clause?
I'm
Or is
explaining
it
why I
not that
don't
motion
support.
or-
I'm explaining why I don't support NDP 1, because I support Lib 1, which is a conflict of lines and which is a similar type of amendment. Point
Okay,
of
so,
order.
I was going to read that. Once moved, that's me, so you've moved it. If
know
NDP 1 is adopted, Liberal 1 cannot be moved due to a line conflict. So I guess the question that I'm wondering, and should I had a speaking list as well, but should I,
Chair, I'm speaking to NDP 1
yes?
and explaining why I believe Lib 1 is preferable to NDP 1, which is why I would not be voting for NDP 1. It's perfectly in order.
The thing is that the speakers, this is here.
No, but I thought, right, but I thought I was on the speakers list. That's why I was recognized.
At the top of it.
Oh, okay, well, that's a totally different question. If I'm not on the speakers list now,
Yeah, well, I think you've already made your point. Have you?
well,
Go-
no, I'd like to speak to it eventually, but of course, if I'm not the first one on the speakers list, I was then erroneously recognized, no problem. Absolument. So sorry, Madam Chair, if I'm
No,
not on the
you're
speakers list,
making
please
your
come back
point
to
on
me.
the amendment, I guess.
No,
No?
there's no amendment. I'm on Randall's amendment. I was speaking to Randall's amendment. But if I'm not the first one on the speakers list for Randall's amendment, am I or am I not?
I wasn't sure if you're making an amendment, is what I'm
No,
asking you.
but on the speakers list wouldn't depend whether I was making an amendment or just speaking to it. Like, there's no advantage to somebody who's making an amendment.
Mr. Moore, Mr. Caputo, Mr. Fortin, Mr. Osborne.
Am I the next person on the list or not?
All right,
I
so,
think my question is really simple.
so we do have a list, and you are on the list. Let me
But I'm
just,
not the first one on the list, so
That-
then I shouldn't be recognized, and that's fine.
Right.
No problem.
according to what I've got written here on my left side.
No problem.
You've
No
got Mr.
problem.
Moore, the first one on the list. Unless he wishes to cede and change with you, that's fine.
Well, no, I mean, Mr. Housefather's points are well taken because, Madam Chair, as was just mentioned, and it's important for us to know this, I think, you know, I have a number of questions about NDP 1, but the fact that you have ruled that if NDP 1 passes, Liberal 1 drops. So it's impossible not to look at them together. Obviously, we would only want to go with one or the other or neither, depending on our views of the legislation. So I guess I would ask focusing now on NDP 1, because that's the one we're on, if I could ask our departmental officials, a lot has been said about exhausting appeal. We've heard witness testimony on that. There's I think, a significant public policy reasons and interest not to gum up our justice system, not to create a parallel justice system where someone could say, oh, I was convicted. Do I go the appeal route, or do I go I was wrongfully convicted, or I had a miscarriage of justice route? And lawyers advising their client on which would be the most advantageous route to take. So could the departmental officials maybe walk us through how NDP 1 would change the change Bill C-40, and maybe how it compares to Liberal 1, if you're prepared to do that? I guess it's impossible not to. I wouldn't want to think that Liberal 1 was better or worse while we're considering NDP 1. So could you just walk us through first the effect of NDP 1 as you understand it?
Thank you, Mr. Moore. And
Madam Chair,
Oh, no, yes, no, absolutely. And Madam Basner, please go ahead, yes.
I thought
No,
you were.
no, absolutely,
I mean,
yes.
are you prepared to, through you, Chair, if you're
Are you
prepared
prepared to speak to that
the
today?
effect of
Just
NDP
in
1?
terms of, description, I could,
Okay.
to the
Yeah,
extent that I
Madam
can, I
Basner,
will.
yes.
So NDP 1, as I see it, proposes to replace subsection 6964 sub 4 entirely, to allow the commission to decide that an application is admissible even if a court of appeal has not rendered a final judgment based on any factor that may have constrained the applicant's ability to or opportunity to appeal the finding or verdict. In addition, the motion would amend subsection 2 of that same provision, which is the exhaustion of appeals admissibility criterion, to allow applicants to include information they believe should be taken into account by the commission in deciding whether to admit the application despite them not having exhausted their rights of appeal. And one thing I did observe, though, in the manner in which the motion is worded, that the amendment to subsection 4, the exception provision, it says despite subsection 3A, I believe. I'm trying to find the motion itself. So it doesn't speak to what would happen with subsection 3B, which is when someone had an issue that they could have appealed to the Supreme Court. So in terms of operationalizing that, I'm not quite sure what effect that would have.
Madam Chair, on
Yes.
that, I think, I mean, there's going to be a lot, I think there's a lot to digest here with NDP 1. It's a substantive amendment, I think, reconciling it with Liberal 1. And at this juncture in the meeting, I know we were scheduled to go from 3:30 to 5:30. And I know some of our members have things, that have adjusted their schedule based on that. So at this point, I think we would make a motion to adjourn the meeting for today.
Okay, so we have a motion to adjourn. Do we have agreement? Okay, I hear heads nodding as yes. Meeting adjourned.